Okay, so we can start. I will also tell you that I was living in Strasbourg 25 years ago, and that's how my story with human rights started when I arrived to Strasbourg. And I have to admit that I didn't know anything about human rights. I didn't know anything about also the European Court of Human Rights. Everything that I learned was there, and at that time, the European Court of Human Rights was hiring young lawyers for a certain time, and then we were supposed to go back to our domestic countries, which I did. I became a qualified lawyer, and to spread knowledge about the convention, which I'm doing, also by running everyday lectures for Polish lawyers. But I have to say that, unfortunately, European Convention of Human Rights, despite the fact that it's a direct instrument of running the law and it's implemented in our system because it's international agreement. So you can call the provision of the European Convention of Human Rights in front of the domestic court. It's not very often that I have a chance to talk with the domestic courts about the convention. Sadly, the practice is that I do quite a number of the cases before the European Court of Human Rights. My main practice is to draft, run, and represent clients before the European Court of Human Rights. But this is the relation between me and the European Court of Human Rights. In domestic proceedings, when I have an opportunity, I'm trying to invoke the standard of the European Convention of Human Rights, but it's very hard still after many years when Poland joined Council of Europe and signed the European Convention of Human Rights. Still, I have a feeling that it's like a foreign planet for domestic courts, and the judges do have problem with implementation of the judgments given by the European Court of Human Rights. So that's why I think it's very important in the legal studies everywhere to talk about the convention and talk about the values and profits that is from the judgment the European Court of Human Rights give. So, as a lawyer, I can have a situation when I'm running the domestic proceedings and I see that there is the problem, and then if I lose, I bring the case to the European Court of Human Rights. But this is not very often since I'm not doing a lot of domestic proceedings right now. But if it happens, as I said, I'm trying to convince the court that there is the issue, that there is standard of the European Convention of Human Rights. I'm trying to present the judgments given in previous cases, but it's very difficult. So right now I finished one case of couple that was not informed about possibility of prenatal examinations, which resulted from doctor's mistake because they were not provide the accurate information. As a result, the woman gave a birth to a girl touched with Down syndrome. So they raise a child, and they claimed just satisfaction before the domestic court for the harm they suffered, and they claim compensation for the cost they had to bear because of raising a child touched with Down disease. So after 14th years of the proceedings, two times the case was quashed by domestic courts. Once we had additional application with the European Court of Human Rights regarding length of the proceeding. This proceeding was ended in July this year by the Supreme Court, who stated that yes, just satisfaction was awarded in the amount of 50,000 euro, but no compensation, because giving birth cannot be regarded as a damage. Yes, so this is the Supreme Court said that if you give a birth, giving a birth cannot be regarded as damage. So this is the case that I built to the European Court of Human Rights. It was just lodged, so I don't know what will happen with this application, if the court will accept, because you know that the European Court of Human Rights doesn't accept all the applications for many reasons. I think the number is like now 80% that declares the cases inadmissible. Of course, sometimes the court accepts the case and then declares the case either inadmissible or rules that there was no violation. So as you see, the first possibility for me is when I'm running the proceedings. I see the problem from the very beginning, and this is very important, that if you're thinking about running the case to the European Court of Human Rights, you have to remember that there is a rule that you have to exhaust domestic remedies. So you have to give a chance to the state and the court to recognize those rights, but also you have to give those arguments that you will later put in your application. So you have to somehow anticipate and foresee that if you have to go with this case in the future, already in the course of the proceedings, you have to give all the arguments, especially those that you see they are connected with the standard of human rights and European Convention of Human Rights. Because if you don't raise the argument before the domestic court, you can't raise this argument in your application. You know this rule here, right? So, and the European Court of Human Rights, it's called subsidiarity. Put recently, this rule was put into the convention that this is the role of domestic courts in the first place to obey and to invoke the convention, and only if you raise the arguments, then you can put it in your application. So this is the first situation. The other situation is when I have clients coming to my office and they said, we have this case, we finished this case, the case is over. So what do you think? Can we complain with the European Court of Human Rights? In many of those situations, I have to say no. And it's very stressful and very painful because people come with the approach that for sure, because they lost, they feel that the next step, natural, is the European Court of Human Rights. And it's not always the case, as you know, because first of all, you have the time for lodging the application. You have to exhaust domestic remedies, what I said. And also, as I said, you have to raise the arguments that you're going to put in your application. So, for instance, people come and say, oh, we have these proceedings. It's been 20 years when we were fighting for compensation or something. And I'm asking, okay, have you filled the complaint against length of the proceeding? Oh, no, we didn't want to do it because we didn't want to upset the court, so we didn't lodge it. Okay, so then you don't have the complaint with the European Court of Human Rights. Even if the case was 20 years, you cannot complain because you didn't exhaust domestic remedies. So in many situations like this, people feel disappointed because also they feel that, especially in criminal cases, that if they were sentenced and they have the case because the domestic court didn't look into my evidences, didn't approve my evidences. So they think that this is about the so-called justice and fair trial. But in reality, you have to raise really a strong arguments before the domestic court and then before the European Court of Human Rights to have a case. Another situation that happens to me from time to time is because the European Court of Human Rights requires that the applicants should be represented by the lawyer since communications of the case. So there are people who, and this is quite a number of people, who lodge the applications to the European Court of Human Rights by themselves. And I would say that this is quite a number of people who, for instance, detained persons who with success draft quite successful applications. So at this stage of communication, so you know the communication is the moment when the government learns about the application, and also the European Court of Human Rights shows to the public the case because it's visible in HUDOC. So from this moment, the applicant, in most of the cases, not in all, but because now also the European Court of Human Rights changed that, for instance, in cases where it's visible that it's going to be a friendly settlement, the cases of length of the proceedings, they don't require a lawyer to assist after communication. So this is the first situation where I can assist as a lawyer since the case was communicated. So at this point, do you have some questions or something was unclear? You want to ask about something?
Do you have any questions?
No, I think it was very clear.
Yeah, I also think you explained it quite well. Thank you so much.
So, as you know, the result of the judgment of the European Court of Human Rights have a double impact. First of all, it gives a satisfaction for the applicant that, you know, I was right. It took 15 years or maybe 20 years regarding that the domestic proceedings are quite long and the proceedings before the European Court of Human Rights are not short. That in the end, after many, many years, I was awarded compensation, just satisfaction, or I was admitted that I was right in my rights. So this is very important for the applicants. But more important is that the judgment gives a signal to the governments of the countries that are in the Council of Europe that certain mechanisms are not working well in the country. So, as you may know, each of the judgment goes to the execution, yes, and the court is not dealing with the execution itself. It's the Committee of Ministers, yes, of the Council of Europe, who is proceedings with the execution of the judgment, and the judgment is so long in the execution unless it's agreed that there's been a remedy introduced to create a situation that never again such violation will happen. And of course, you may know, I don't know the situation in all the countries, but regarding Poland, there are many judgments that were not executed. For instance, the whole group of so-called reproductive rights. There were cases, Tysiąc against Poland, RR against Poland, PNS against Poland, who remains unexecuted since 15 years. And I'm sure that such situation also is in the other countries. For instance, I know that in Azerbaijan they don't also execute the judgment. I think they even don't pay the the compensation that the court awarded. So if the countries, if the governments do not execute the judgments, we have the situation when not only those judgments are standing by execution, but also that there is no stop for the further violations of the convention. So the mechanism that is designed to stop and to prevent from the future violation is not working because the countries, the government do not execute the judgments. Now in Poland, for instance, we have a huge problem with the execution of the pilot judgment Wałęsa versus Poland. Wałęsa is a former president of Poland, and he lodged one of many applications regarding the changes in the judicial system of appointing the judges, especially at the Supreme Court. The European Court of Human Rights almost 2 years ago, because on 23rd of November gave a so-called pilot judgments. Do you know what is a pilot judgment?
No.
No, the pilot judgment is when the European Court of Human Rights sees a systematic problem of violations of human rights in the country in certain area and already got a significant number of the applications regarding the same allegations at the same subjects. So it means that there is a number of cases at the European Court of Human Rights. They touch the same exactly the subject, and the European Court of Rights decide to give a pilot one, the first one, and give a time to the state to repair the mechanism that is not working. So in Wałęsa versus Poland case, this is the question and problem of appointing the judges, the shortcomings in appointing the judges, and the wheel is running all the time. So there are more and more appointment of the judges. So for the first time, the European Court of Human Rights gave 1 year to Poland to repair the problem. Poland failed. So now on 21st of or 23rd or 23 of November, we will learn if the European Court of Human Rights will prolong this time for the government to introduce measure to execute the judgment. But it may not. The court may not prolong this another year, and then I don't know what will happen. So as you see in theory, the mechanism for the European Convention of Human Rights is designed in such a way that by the execution of the judgments, we shouldn't have repetitive judgments. We shouldn't have repetitive violations of the law. But as I said, in many countries, the governments fail to execute the judgment and also fail to implement the standards of the European Convention on Human Rights in their domestic system. Now the questions also.
Yes, because if the country doesn't want to execute the judgment, the court can do anything about it, or it's like
the court role ends up basically with the judgment. Only when there is the pilot judgment, the court gives a time saying, I have here 1,000 application. If you don't do anything about it, we will just make all the judgments with compensation and everything. So with the pilot judgment, the court gets a chance to repeal quickly the mechanism, and then the European Court of Human Rights will probably just accept friendly settlement or something. So, then it will be acknowledgement that there is a violation. So there would be no need to give thousands of judgments. This is what happened in Polish cases previously. We had pilot judgments. And I imagine that in other countries also this was the case. Presumably, I think in Italy, the length of the proceedings, Cordino versus Italy, I'm not sure if this was the pilot judgment, but for sure there was the problem of the length of the proceeding and lack of effective domestic remedies. So that's why the court is also overloaded with repetitive cases, yes, because in many situations the court stressed that we would like really deal with difficult questions and subjects such as environment. You heard probably about the recent judgment of the European Court of Human Rights given 2 years ago against Switzerland, when a group of old elder women in Switzerland complained that Switzerland failed to do more efforts to protect the environment, and as a consequences, that change of climate and rise of the temperature causes that in summer they cannot run all outdoor activities, and so the court could deal with more eventually effective systematic violation, and it could be more speedily. But the reality is that there should be a balance between the court's job and also what the governments are doing. So you also have to know that as a lawyer, when you are dealing with the case with the European Court of Human Rights and you have a judgment of the European Court of Human Rights, you are entitled also to supervise the execution of this judgment. So when you go to HUDOC and you see the list of the judgments, on your left side, there is also HUDOC execution. And you see the whole proceedings about how the state explains what is the stage of execution of the judgment, what the measure they implied. And you can also, as a lawyer, call some NGOs and invite them also to give the statement, what is the stage of execution of the judgment. So this is also the role of the lawyer if he or she wants to be involved. And of course, every judgment might be different, because I had the judgments where I knew that lots of NGOs were involved and interested in supporting the case, and they lodged amicus curiae, and I was not alone with those cases. For instance, the cases regarding reproductive rights in Poland. But also I had case that I was lodging against Norway, that was about intervention of so-called barnevet. So the social security took over the custody of a child, and I couldn't find any NGOs to support the case against Norway. So of course there are subjects, there are society NGOs are more interested, and sometimes not. I don't know about your experience if you read about the cases, yes. So if you feel that this is interesting, or this is boring, or this is another case, or this is something that doesn't apply to my situation. So the cases of the European Court of Human Rights are very various. It's like it's the prisoners' rights, it's environment protection, it's family law. So it's very, very spread subject. Yes, the subjects they are developing also it's surrogacy, rights of children born in surrogacy, forced migrations. Yes, we had a big hearing against Poland case called LA regarding the situation on Poland's borders. So the subject that the court deals with are very, very different. Yes. So, and they changes through the times because as you know also, as we develop, yes, so the questions also of communication, internet, artificial intelligence that will come probably soon. Those are old fields that the European Court of Human Rights will have to um, deal with. No questions or marks or something?
Anyone has some question or a remark? It's just a silent. Okay.
So regarding the judgment that I showed you and presented, this is the last judgment that I received from the European Court of Human Rights because as I represent the client, I can obtain a judgment, but also lots of cases ends up with friendly settlement. So in many cases, the European Court of Human Rights proposed that the parties would conclude friendly settlement, and even if the applicant doesn't want to conclude the friendly settlement, the government has the opportunity to present unilateral declaration when they are admitting that there was the violation of human rights, and this is in practice ending up the case, like the government when admitting that there was a violation of human rights, the court says, well, the aim was achieved. You have the acknowledge from the government that there was violation of human rights. The European Court of Human Rights, in many situations like this, doesn't see the point to run further the proceedings and struck the case from the list of the cases. So it's not often when your success is the judgment. And also the other situation when the government wants to, as I say, chop the head from the case. Like they want to conclude the friendly settlement or they declare that they violated their rights because they don't want the case to become a judgment. As a judgment, the case is more visible. As a friendly settlement, well, with declaration they will pay compensation and the case is struck from the list. It's not visible. I mean, this is the satisfaction for the applicant, but it doesn't have the second impact. So it doesn't create the situation when the government have to execute the judgment, as I said, in the execution proceeding such a way that such violation will not repeat. So when it comes to the point that I get the proposal of friendly settlement or declaration, I have to think about two things. First is the client's interests, because often the client make great effort to lodge the application, to come with the case, to also go through the whole proceedings before the European Court of Human Rights, even if he is represented by the lawyer. It takes time. It takes time. So sometimes people get older and they say, well, I cannot continue this case because, I'm just I'm just done. I'm just tired with the subject. And then there's another interest that you have to put and see, is this case important to be visible in a judgment? So in in one of the reproductive cases, the government immediately proposed the friendly settlement. And of course, for my client, taking the money and saying, "Okay, this is the end of my nightmare," would be satisfactory. But she said, "No, no, I'm not doing it only for myself. I'm doing it that such situation will not happen to the others." And this is great approach of the victims, because as a lawyer, you will not have a case if you don't have a victim. So you have to have somebody that will come and say, "I want to do the case. I want to tell the story. I want to reveal the details of the case." Of course, the court may grant anonymity to the applicant. But honestly, if you know all the details of the case, it's not sometimes difficult to guess where the case come from, who is, but even if it's not about it, but it takes a certain courage to do the case, and also the experience that I had, for instance, with reproductive cases. That first of the case that became very well known in Poland, and the judgment was given in 2007. Was Tysiąc versus Poland on access to legal abortion. And this case was done under the applicant's name. But because the applicant got so many negative situations and stigmatization, next cases we decided to do anonymously, because we didn't want to reveal the face of the victim, who already suffered the violation of the human rights, already had to go through domestic remedies to a certain extent. It was not always the case, because sometimes you don't have the domestic remedy and then you can go directly to the court. But still, showing your ID, showing your who you are, is sometimes too much for many applicants. And of course, they might be protected by granting them that the case would be anonymous. And this is the case what I presented to you. So LD versus Poland is the case where the court granted the applicant anonymity. Yes, so we do not see the name of the victim.
Sorry, there is a question.
That's why I wanted to ask if there are questions.
Yes, I see Gloria wants to ask something.
Hello. I find it very interesting so far. Thank you. I was just wondering, like, because we're talking a lot about the victims, which is the main purpose of all judgments. But as a lawyer, I would also be interested if there is any pressures, for example, in this between friendly agreements or making a judgment, like from the other kind of the party that's engaged. Maybe if it's the state, like they have maybe they're interested in doing a friendly agreement. So how is it for a lawyer to deal with that also? And maybe is there some pressure or like lobbying, or I don't know, like how does that work if there are strong interest on the counter side? And yeah, how it's dealt as a lawyer if there are
You have
challenges.
to remember that when you have friendly settlement proceeding, it's confidential.
Okay.
It's confidential. You cannot reveal to the public that there is such stage of the proceedings. They were lawyers, at least two I heard in Poland, that they were not aware of this, and they revealed to the public that yes, in this case, the government proposed us 20,000 euro.
Then
End of the case. Because also you have to know that the lawyers working on the case from the country the lawyers from the country. Yeah. So in Spanish team, they are Spanish lawyer. In Polish division, they are Polish lawyers. So sooner or later, they will divide discover what was happening. So you are a little bit alone with the decision about what to do, and this is. Also, how strong you see the case, and what is the potential of the case, and what is better for the victim, because you always have to know that it was already the effort to go so far. And I think many cases regarding domestic violence, yes, now there are lots of cases on not implementing the not having law for LGBT in Poland, for instance, there was the case. So when the government, instead of introducing the law, it's easy for them to do friendly settlement.
Exactly.
So of course, but sometimes you can go with the visibility, because if you have friendly settlement or declaration from the government, the case is struck from the list. So then you can see it in the decisions that the case was struck out. And then, you can write in general about the situation that, for instance, the government is making declaration instead of solving the problem by introducing the law. But you have to be very careful when you deal with the case, because there is confidentiality, and also when the case is grant anonymity, you cannot also reveal the name of the victim to the public.
Okay. Yeah, thank you very much. Yeah. I think there was another question.
Yes, I think Betty also wants to
I
ask.
also feel that way. Like I think my question is pretty much like similar to your question, and my question is about like the protection of the client interest and the government accountability. So like yeah, friendly settlement and the judgment. So my question is whether these two things can go together, although the friendly settlement, from what I understood, should be confidential. Like, can the client get the monetary compensation, for example, and the government can be held accountable by I don't know, yeah, by the judgment? Is it possible at that cases where these two things went together, or like you gotta choose as a
So this is what is happening, as far as I know, in cases against Poland, because I'm not familiar with all the cases against the other countries. I don't have capacity to follow all the judgments against other countries. But in Poland, there was the case regarding lack of legislation for a couple of the same sex. This is the case Przybyszewska versus Poland. And the European Court of Human Rights said that this is the breach of positive obligation, not having such law and recognition of such couples. And since it gave its opinion, it gave the judgment, and still other cases are coming into the court. So for the further cases, it's not need to rule on them, because it's been already ruled that Poland violated the European Convention of Human Rights, but by not having this recognition and this legislation. So what the government is doing, the government is making declaration, and for the government, it's easier now, because in Poland there's the whole discussion about recognition of the same-sex couple marriages and relationship and LGBT rights and children's rights in such relations. So Poland is not introducing the law, because it's easier for the government to sign the declaration and to continue the violation, in fact. So
yeah,
you
like
So you see, this is also also the thing that sometimes by declaration the government can continue on violations of certain rights by admitting, yes, we violate those rights, but they keep not improving the mechanism or introducing the mechanism.
So like my question is based on what you said. What are the consequences? Like, is the European Court of Human Rights supposed to hold accountable the country which is not?
It's not the European Court of Human Rights. The European Court of Human Rights ends up his role when it gives the judgment. It's the execution. It's the Committee of Minister of Council of Europe who is dealing with the execution of the judgments. And if you go to the website, you see that there is the whole proceedings of execution. And also, for instance, NGOs can send information about what is the situation and why this judgment is not being executed. So they inform the committee that this judgment should stay on the list as long as it's not fully executed. Because I will show you maybe the website.
Okay. So then a country can like violate human rights.
So if you go to HUDOC, yes, and here you have HUDOC execution, yes, and for instance, there is the case. Rutkowski against Poland. This was the case about an effectiveness of the remedy against length of the proceeding. As you see, the judgment was given 2015, yes, the final judgment 2015. And since this time, this judgment, even if it's leading, remains unexecuted because Poland didn't improve the mechanism which would be effective complaint against length of the proceedings. So this judgment is staying in the list of execution since 10 years, and it will stay as long as the committee will decide, okay, Poland fulfilled the obligation by improving or introducing here, improving the remedy, and then we can struck the case. But now lots of people still complain exactly the same as this case. They complain to the European Court of Human Rights about the length of the domestic proceedings. And in most of the cases, the government is making declaration. Because what we can discuss about, this is obvious that the domestic remedy is not effective. We know it. The government failed to execute the judgment. They failed to improve the remedy that was introduced and remains ineffective. So we have a situation when we have it was even a pilot judgment. So we have a pilot judgment, but we have the situation that the government fails to execute the judgment. And since the next cases are coming, the government is making declaration and that's it. So it's like what we can do.
So there are no real consequences for the government, basically.
I'm not aware. I mean, I know in theory that, there are some consequences, but I don't know as much international law and agreement between the countries in Council of Europe to discuss about it. What are the consequences if the country doesn't execute the judgment? But it happens that there are certain judgment that remains unexecuted. Let me see. Where is this page? You can still see it, yes? So, for instance, also the case that I mentioned. What is the year? Well, 2007, yes? Almost 20 years. So, and still leading case. If you go to the case, also you can see all the documents that we're presenting. So you see, since years, the government is presenting, NGOs is presenting their statement why this case is not being properly executed. Look how many documents there is. So of course, this is the problem, that it's not on the European Court of Human Rights side. It's the problem that is on the governments, that they are subjects, and the judgment that the government, they don't want to execute because they need to change the law, they need to introduce some measure, or they need to improve certain measure. And because of some political issues or some other things, it doesn't happen.
Can I?
Yeah, you can.
And like, do you think that this raised the question on the validity of human rights law, or like?
Can you repeat? Sorry, because.
Do you think this type of circumstances raise the question on the validity of human rights law? Or
No, the thing is that when we talk, we talk about some extreme examples. Yes, I mean, we talk about the case or cases that were not executed. At the same time, there are many judgments that were executed, that led to change of law, that led to changes in Europe in many ways. I mean, if you go to the European Court of Human Rights page, let me see if I can do it properly. There is a movie about multimedia. I'm not so good at this, but let me see, maybe communication hearings, applicants. Yes, this is the film on the court. If you see it, later, it takes 50 minutes. There are many examples. Maybe you know this movie. Do you know this movie?
Which one?
We don't see it. We don't see.
You can't see it?
No, we can't.
Okay, one more time. Sorry. Now, can you see? So I went to the European Court of Human Rights page, and then I went applicants, and then I went down, and there are 3 movies, yes? And here's film on the court. Do you know this one?
No, I don't.
Okay, so you can watch it. You can watch it later, and then you see many examples of the cases against various countries when the European Convention of Human Rights was an impact on domestic law. It led to introducing new law. It led to changing the remedy. It led to many changes. So, of course, I gave you the extreme example of the situation when the judgments were not executed, but in most of the situations, they are being executed.
Do we have this question also?
Well, maybe just the last remark, coming back to Poland, I would just be maybe interested, which are the latest main topics that or subjects that are brought to the European Court of Human Rights in like from Poland, I mean.
From Poland, okay, let me see. So if you want to see all the cases against the countries, if you go to the page of European Court of Human Rights, you have two ways. Well, first of all, you have something like downstairs here, you have country profiles.
Yes.
Do you know this?
Well, I'm seeing it now.
So this is like country by country, the most important judgments against certain countries. Also, you have very interesting fact sheets when you have the judgments summarized by the subjects. This is also very interesting. Also, you have this platform here that the European Court of Human Rights introduced a couple of years ago. It's knowledge sharing, where also you have guides on certain articles, which is very, very useful. If you search for information, it's just here. And also, I'm checking HUDOC from time to time to see what's going on. And regarding Poland, you have two ways. So first of all, you can see what judgments were given against certain country. This one I don't know. Siedlecka versus Poland was a journalist who was in manifestation, and for a certain time she was blocked and she couldn't move. So she was regarded as being detained, and she complained that during the demonstration she was not allowed to leave and to move. So she complained about the situation. Sadomsky, I think this is also the judge complained, because now we have lots of situation with the judges. Zakrzewski was a very interesting case about the man who was sentenced, and then he left the prison on parole, and meantime the Ministry of Justice complained against the judgment that was given to him, and even if he was released from the prison, after a certain time he had to go back, and the European Court of Human Rights found the violation on Article 6 regarding certainty of law and situation. Grzenda versus Poland. It's again the judge case. WW is a case of a detained person who was in proceedings of change sex, and the person was refused to receive medications in the process of changing the sex, because the person was detained and was refused. Friedrich and others, it was Greenpeace ship, and also the members of on the crew were detained somehow. Pietrzak and Bychawska, it's the lack of the remedy. If you want to check if you are listening in inwigilacja, invigilation.
Do you know this word?
You say invigilation?
Invigilation?
I'm not sure about the word in, let's see, also when you go to the judgment, it's always,
Languages and other.
yeah, but this will be in Polish, so it's not helpful.
I'm check on the translator.
know, it can be, it must be in
In French?
surveillance secrète,
Okay.
Also
Surveillance secret.
surveillance.
écoutage.
Mm-hmm.
I don't know how it's listening in English.
Yes. Well, not spying, but listening in, surveillance,
Surveillance, yes, exactly. Thank you so much. Yes. So this is, but also if you want to see, you know, what's going on with Polish situation, then of course you go to communicated cases. So then you see what was communicated, not by judgment, but what the problems were brought before the European Court of Human Rights. So this is the moment. So sometimes also I'm looking at those casings saying, what's going on. Yes, but here I don't know all of them. For instance, you know, this was the case here that I concluded the friendly settlement because it was about um, length of proceeding regarding death of the applicant's wife. And I found that, you know, already there were number of cases touching the same subject, so there will be nothing new that the court can say about the standards. And it's more important for the applicant, that is quite older people, to receive money and to finish the case than to continue and have the judgment. So like here, you know, and this was more important, yes, for the client.
Yes.
Um,
Yeah. Thank you. I will take a look at the website. Yes.
so the website of the European Court of Human Rights is really full of information. I mean, whenever you look for there are also lots of judgments that are translated into your national languages, which is really helpful. I mean, it was not the case in the time that I was starting working with the European Court of Human Rights. I had problems with translations. Now you have easy peasy. Also, you have Google. Yes, I mean, and 20 years ago, believe me, it was much harder. Also, when you want to present the arguments with the domestic court, I mean, you need a good translation, because saying the judges, yes, you can find in HUDOC, they don't know what is it.
Yes.
So just very briefly about the case that I present you. I chose it for this certain reason. It's because if you see in the beginning, it's marked that this is the case about positive obligations, and this is my, if I can say, favorite term in human rights, because it regards the field in which the state must act to protect our rights. The human rights are not only about intervention into our rights. It's not only about when the state takes something from us or forbids something, but it also when doesn't fulfill this positive obligation to have mechanism or help us or act that we would enjoy our rights. So this case that you see was on family law. It was about dispute where the child supposed to stay either with the mother or with the father. The child was taken from the mother. The father didn't want to give back the child. The mother started the proceedings. The proceedings lasted quite long. But this, what the court said, that when you have conflict between even third parties, so it's not even conflict between an applicant and the state, but between the third parties, in family cases, the state have an obligation to help to dissolve the problem in order to protect the child, for the child's best interest. Yes, because the child's best interest is to have contact with both parents when they don't live together. But positive obligation is a very wide term that applies to many situations and many articles. You have positive obligations under Article 2, you have positive obligations under Article 3, 8, 10, and also the judgment that I mentioned against Switzerland about protection the environment. Also is the judgment on positive obligations. So something that the state failed to do in order to protect our rights. Can you see? Yes, does it work?
Yes.
So this is the case. It's like, sorry, I don't speak German. Case of Verein, Klima, Seniorinnen, Schweiz, and others versus Switzerland. So it's translated into Czech, German. Not yes, but it's also positive obligation. So this is the term that also was in reproductive rights case, Tysiąc versus Poland. Also, it was about positive obligation. So in many judgments, the European Court of Human Rights apply this term for the failure of the state's obligations to protect our rights. I think it's very important to be aware of that it's not about taking our rights, but it's also about acting in order to protect them by the state.
So it's like in Polish zaniechanie, right?
Czy to jest zaniechanie? Yes, you can say that it's negligence, but the term that you are using is positive obligation. So we say that there are some obligations by the state to protect our rights. So it's not only about intervenience, yes, about when you have a situation about taking the property, taking your child to the public custody or something that the state acts, but also the state's negligence to act in order for us to feel well with our rights protected. Do you have any other questions? I hope I was clean. I mean, I don't have so many also chances and occasion to speak English for so long. Usually the proceedings with the European Court of Human Rights is written, so it's a little bit different because always I have a chance to correct my English. So I hope everything was clear for you.
Yes.
Yes, you
Thank
speak
you.
very well.
Yes.
And it was very interesting. Thank you.
Did you have a chance to visit European Court of Human Rights?
Actually, yes, we attended the open days.
Ah, yes. So did you see the convention?
Uh,
Because I heard the document of signing the convention was revealed to the public and you could see it.
Yeah,
Wall.
with the
Mhm.
Yeah.
Yes.
I had the opportunity to speak with two.
Lucky you, I haven't seen it.
Yes, we also had opportunity to speak to judges.
Mhm.
It was a very interesting event for us. Yes.
Yeah, I know that there was open door days, but I think also you could maybe try to attend some hearing. Is there anything going on with the schedule with
Are we
Yeah,
allowed
in
to?
November we want to try. There's an Italian case.
because there is the whole proceedings to get inside the calendar of hearing. Yes, it's in November. It's very few now hearing. It's less and less. I mean, this is also the way the court is working, that there used to be more hearings generally, but now the court is like, it's even fully booked. Okay.
Yeah, we wanted to try, no, but we didn't get it.
Okay. Okay, sorry. But you can see it online at least. You know it. It's like it should be also I don't know if it's like at the same time when the hearing takes place, or it's later, but at least you can see it on, like here. Yes, you can see it on webcast. And also there's like old also webcast you can see. So all good luck to you.
Thank you so much. Thank you so much.
Profite bien à Strasbourg.
Merci.
Enjoy and good luck. And thank you for inviting me.
Thank you for your time.
Thank you. Bye.
Thank you so much.
Bye.
Thank you so much. Goodbye.